Okay, hello and welcome to our webinar today. We are looking at UK group litigation, a class of its own. There's a couple of things I want to just go through before we get going. You can submit any questions by typing them into the GoToWebinar panel. You're welcome to submit questions throughout, and if we don't answer them throughout the presentation, we'll try and address them at the end. And the webinar will be available on a recording afterwards if you would like to see it again or share it at a later date. To start with, so we're looking, the subject of today's is the group litigation in the UK. So we're looking at the rise in group litigation in the UK and discussing recent developments in the area. And the technology which can be used to efficiently manage these matters. Today on the panel we have myself. I'm Martin Flavel, the UK Director of Sky Ducksbury. Sky Ducksbury is a consultancy-led service provider offering e-discovery, e-disclosure services and technical solutions to the legal industry. And we're a Relativity Premium Hosting Partner, which is one of the market-leading document review platforms. We have developed automated tools and workflows within Relativity for the Australian market to manage class actions, and we've modified these tools to cater for group litigations in the UK. So we're the guys really that offer the technology here. I'm joined today by Clare Ducksbury from Case Pilots. Case Pilots provide consultancy and project management specialising in group litigation work. Clare has been instrumental in the administration of various high-profile and significant group actions in the UK. And I'm also joined by Stephen O'Dowd. Stephen is a Senior Director at Harbour Litigation Funding. He has previously led litigation teams. He has an in-depth knowledge of assessing group litigation, and will be giving us some insight into how third-party funders play into these matters. So just to quickly go over the topics of today, we'll give you a quick overview of the rise in group litigation, some key considerations, and some recent developments. We're covering, the corporate claims, and then having a look at the funder's perspective on group litigation, and then on to the technology and having a look at the automation and that side of things, and also how to promote your claim. So firstly, I'd like to hand over to Clare to start us off. Thank you, Clare.
Thank you.
Sorry, I need to I'll just unmute you there for a minute. Okay. Thank you.
Thank you, Martin. And thank you to all of you joining us, which is during inevitably your lunch hour today. It's certainly no newsflash that group litigation is on the rise outside the US and Australia. I think it is by no coincidence that this is happening in parallel to litigation funding also being on the rise in respect of both the level of funding that's now available, new funders in the market, and what I'm seeing is a funders' increased interest in group litigation. If we look at the competition arena, we have, of course, the Consumer Rights Act, which is now a couple of years old, which does facilitate the collective proceedings in CAT. Perhaps there's more trying and testing to be done there, but it does at least begin the facilitation of a form of class actions within this jurisdiction. We've also seen a lot more retail and institutional shareholder claims, typically sort of the more topical ones, or RBS, Lloyds and Tesco's. This is probably, the foundation of this has probably comes from the United States Supreme Court back in 2012, really limiting the extraterritorial application of the US securities laws. And generally, I think all of this goes hand in hand with the public and the corporate community being more comfortable with the process of class actions and group litigation, and a growing enthusiasm to be involved in this. Especially for the major shareholders. I think we're seeing shareholder activism on the rise, and shareholders taking a much more active stance if they're not happy with the strategy or the decisions of the companies that they're investing in. We've also seen, of course, looking at the competition area, sort of an increase in enforcement of competition law in the UK courts in recent years. And interestingly, I was at a forum this morning, a competition forum this morning, where Michael Grenfell of the CMA talked quite animatedly about their future plans, and he highlighted the fact that they had imposed their highest fines ever last year, and they'd also for the first time used their power of director disqualification. I think that together with the centralisation of leniency applications, which is on the horizon, for at least for the immediate future, of course in the long term it is designed to act as a deterrent, but in the immediate future I think we can expect to see that leading to a lot more leniency applications and therefore a lot more follow-on litigation to arise from that. And what does that all mean? I mean, really that's only good news for all of us who work in this area. But beyond that, I think it's good news for anyone who wants to get into this area. And as the slide alludes to, you know, our ethos and our belief is very much that with the correct combination of legal expertise, funding, technology, project management, the right team can make a very successful stab at pursuing these cases. Moving on to what I see as some of the key considerations, of course, first and foremost, which isn't covered in the slide, is a good legal team and a good legal strategy. That's really the very beginning. Project management, well, that's a very overused and generic term. What does it mean in the context of group litigation? I think we're talking about project management not just with regard to the legal approach, but also the back office administration of all of the information that inevitably will be collated both at the outset and during the course of group litigation, and all of which can be used to underpin the case. Use of technology, and that's very much where Martin and his team and his solutions come into play. But it is all about, if you're managing large amounts of information, data, documents, it is all about harnessing technology to help you do your job effectively and to help be cost effective in doing that. And that doesn't necessarily always mean using the technology that you're comfortable with or that you're used to, but certainly when you're looking at group litigation, it's about using technology that is fit for that purpose and doesn't have to be sort of bent in order to handle the quite specific dynamics of group litigation. Our belief is that a good combination of this effective project management and using technology can allow lawyers to do the high-value legal work, which is what they're good at, and provide them with the capacity to do more of the cases. This can also, I hope, for the future, will enhance the prospects of acquiring funding and achieving success in the case. And I think the eventual goal here is really to support the development of a framework for successfully handling group actions within the UK. Recent developments, well, there's many to talk about. Some of them will be highlighted and have been highlighted in the slides. I'm sort of focusing in on Merix and MasterCard, a very topical one. That has caused a great difference of opinion, I think, in the legal world, and it's probably a case that could merit a whole webinar of its own for discussion. But from my point of view, what came out of that as interesting reading was that in making his determination, Justice Roth alluded to the fact that at this stage he thought it was impossible to determine pass-through as a common issue, and the case required a proposed method that would lead to payments on a compensatory basis. Basically, that means, in my reading, some upfront thinking with regard to group profiling and post-settlement distribution and all the bits that happen in between. So, of course, we're talking about the whole life cycle of a group action here. So, right from the very beginnings of setting up a registration page and intaking information from your claimants, to figuring out post-settlement, and hopefully that's an early settlement, how the money is distributed to the right people. There's lots of elements around the whole life cycle, but I think some key points for anyone embarking on this work is to have a very good understanding of the claimant information gathered at the outset, if you've got a dedicated team focusing on on both the data management and the administration of the group action, this can only serve, I think, to support the legal team, and will help us demonstrate that actually group actions can work in the UK, which, let's all hope, can provide an incentive for some early settlements, and can achieve sort of true access to justice. I think my feeling is that having this upfront forward thinking and thinking very much at the outset about the data collation and how that's handled and what technologies are going to be used and what data methodologies are going to be used will only help you in putting together a very robust funding proposal for any funders that you will be presenting to. And of course, we all know that the vast majority of these cases will rely on funding to get them off the ground. And if we take Volkswagen and trucks as two very typical examples, where there are many, many, many firms looking to do this work and embarking on this work, all of who will be looking for funding, and somehow the funders will need to make a decision about which ones they fund and why. And my belief is that a good forward-thinking plan can only assist in that. The next slide, GDPR. Again, this is a topic that would warrant its own webinar, so I won't go into it in detail. But I did just want to touch on it because I think it is of significance when we look at individuals who are bringing a group action. In very basic terms, as we all know, GDPR will apply to all organisations collecting any personal data about individuals in the EU, and the personal data itself is any identifying information about that person. So if you are collating information from an individual about their employment or their purchase of a product, or something that a wrongdoing that they've been subjected to, I think it's inevitable that at a very early stage you will be intaking that personal information. By doing so, you then become accountable for that information, and to show that you are complying with all of the principles of GDPR. So from a lawyer's point of view, who are doing these cases and intaking this data, that very much puts onto you control of obligations to make sure that however this data is being handled post-intake is compliant. Conversely to that, there's obviously the corporate claims. These come in heavily into play when we're looking at sort of competition cases and institutional investor cases. They come with a very different set of considerations. When you're acting on behalf of corporates, bringing one of these claims, you're less likely to have to worry too much about GDPR. But what you will find is that when acting for a large corporate, identifying the actual data and documents and information that you need from them to support the case that's being brought, and doing that in a very targeted and effective fashion without causing too much disruption and interference to that corporate's normal flow of business, it can sometimes be like looking for a needle in a haystack. And that's where people like ourselves, sort of data project managers, can assist in working with you to understand what information is required, and approaching that in a very targeted fashion to get the information from your claimants. And now, Stephen, I'd like to hand over to you.
Thanks, Claire. So I've got two slides, and I'm going to touch upon, I'm going to actually take a step back and just provide some context by way of background. Harbour has been funding claims for 10 years. We've funded 87, and at the moment we've got 45 that we're actively funding, and almost 30% of the claims we've funded have been class actions in 4 different jurisdictions, so Australia, Canada, New Zealand and the UK. I've referred to the pains of running a class action in the UK, which is my first slide, and I'll explain what I mean about that. I mean, the UK can be an interesting jurisdiction to fund class actions because we lack a generic regime or framework to help the parties and the courts manage the group dynamic. By contrast, Australia has a generic regime that earlier this year celebrated its 25th anniversary. Now, the regime is not perfect, but it has improved and become more robust by handling hundreds of class actions over the last 25 years. In the UK, and Claire alluded to this, we only have one dedicated regime for class actions, and it's pretty new. It's the collective redress regime for competition claims in the Competition Appeals Tribunal. It's over 2 years old, and it remains untested. 2 claims have tried to use it, and they have both failed. But in spite of our lack of framework for managing class actions, and again, something Claire touched upon, I completely agree with her, we're seeing an increase in the volume, or certainly the scale, of these types of claims. High-profile examples that have already been mentioned: Volkswagen, RBS, Lloyds Bank, Tesco. My role, or one of my roles at Harbour, is to look after the class actions that we fund, and for me the most challenging aspect of funding class actions in the UK relates to management of the claimant group and its data. And because we lack this adequate regime to help with this administrative burden in most cases, and the burden can be significant, it can be challenging, and it's often underestimated, this burden, by lawyers running the claim. There are lots of excellent lawyers in the UK with good class action experience, but because this space is rapidly developing, we as a funder are receiving more inquiries from lawyers to fund potential class actions, and the lawyers are experienced litigators, but they don't have a lot of class action experience. And then you look at the claimants themselves, again comparing to Australia, you'll find large institutions who are used to participating on the claimant side. Not necessarily the case in the UK. We've funded first-time institutions who've acted as claimants, and they need and want guidance and help to deal with this group dynamic. Which brings me to my 2 slides, the first one being about pains. This is, if you like, peculiar to the UK, and it relates to the structure of the claimant group, and it's the first aspect that I'm going to touch upon, my point being that if these 2 areas are not handled well, it can cause a case to fail. You don't need to worry as much as I'm about to talk about in relation to the structure of a group if you have a class action regime, because you have an appointed representative for the class, and a lot of this is easier. But without that, then question who is making the decisions at key points in the litigation and who is giving the legal team instructions. For the class actions we fund, the claimant group must agree to clear terms of reference, which specify voting rights for material decisions in the litigation, such as settlement, and what happens if there's a disagreement over settlement. I mean, it might sound obvious, but it can be really damaging if a small window of opportunity arises for settlement where the legal team needs to act quickly, and it can't, because it can't secure client consensus because the claimant group structure is not strong enough. In addition, we insist on a decision-making body or committee, usually comprising representatives of the group, usually the main stakeholders. And now, and this is something that we've put in place recently, we also look for a litigation committee to be formed, one that meets at least quarterly. And the idea is that the committee works through, with the legal team and a representative of the funder, an agenda of the key issues that are being managed on an ongoing basis in the case. If nothing else, the litigation committee just helps everybody know what is going on. And in my experience, when you reach one of what will be a number of bumps in the road in your case, it helps enormously if people actually know at a rudimentary level what is happening. So that's the first slide. In terms of my second slide, this can be applied to class actions generally, but it's just as, if not more important. And Claire has touched upon it, but it's about quality control of data, and I'm going to come at it from the perspective of what do we as a funder need to see. So this is quality control of a claimant's data through the signing up process, or what you might call the book build for the group, leading ultimately to settlement or resolution of the case. And I'm going to take as an example a securities class action, a shareholder class action like RBS or Lloyds. We would be looking for a 3-stage process to be managed in relation to a shareholder class action. And the first stage is just a preliminary check. you perform a preliminary check on the claimant's data to check that they're actually eligible to be a part of this group. You review each claimant's submitted trade data and you check that it falls within the class period and that there are no inconsistencies in the data or trading history. And those inconsistencies might include things like you spot that there are trades listed on non-trading days, or trades that would involve group members having a negative balance, or trades at a price that is outside the trading range for the day in question. Once you spot those inconsistencies, you can resolve them because you then seek further instructions from the claimant, and that might include asking the claimant to provide transactional evidence of these anomalous trades, usually with very easily accessible documents such as CHESS holding statements or broker contract notes. You have to bear in mind that that type of inquiry does require discretion, but that first of this three-stage process is just making sure the claimant is eligible to be in the group. The second stage is when you've pretty much got a fully formed group. So your rate of registration has steadied and you've got a substantial amount of trade data from your claimants. Then you undertake a trade data confirmation process. You identify a cohort of claimants who together are responsible for a majority of the registered loss. We usually look for in excess of 90% of the loss being claimed. And the legal team writes to those claimants setting out the claimant's trading history as recorded in the database that's been put together, and ask the claimants to sign and return a document that confirms the following things. 1, yes, this is a correct record of my trading history. 2, yes, I am authorized to instruct the lawyers on behalf of the named claimant. And 3, there's no other person in my organization that has instructed the same lawyers in respect of the same holdings. And then the third and final stage is when you reach a settlement. You require all claimants to provide confirmation of their trading history before issue of an assessment of entitlement. And then overarching all of this, we've found it's really important to have an audit process. So ensure that your trade data is periodically audited for internal consistency and also in an attempt to identify anomalies or duplication in the data that's been provided by claimants. And the scope of your audit will depend on, and the timing of it will depend on how the case is progressing. Now, these are things that lots of lawyers do, but we've also seen lots of lawyers who are not familiar with this. And all I'd say is if any of that sounds daunting, then that's why we have people like Clare and Martin who are here to help. But those for me are two key aspects of claimant group management dynamics that you need to be on top of if we're going to fund a class action.
Thank you very much, Stephen. Great insights there into your perspective on things. I'm going to now follow on with just giving a bit of a brief overview of the type of way that you can use technology to really centralize everything and really control costs and save costs by having everything in one system. There's a couple of things that we assist with at the beginning of the matter. The first part is often just onboarding your claimants, and this is an area which is could be done in many different ways, but in today's environment of social media, etc., it's quite often useful to have the skills of social media campaigns and search engine optimization, and email campaigns and follow-ups, etc., to really to get as many people as you can on board with the claim. So this is something that we offer as part of our service. Is we actually really focus on that part of it to really onboard the claimants. And then we also can put together microsites, which are often seen nowadays for claimants to subscribe themselves to the claim or the action. We sort of go one step beyond just having a microsite. We try and design it in a way which allows us to get all the very basic information up front, very important information up front, including the uploading of any particular documents which may be relevant to it, such as agreements, etc., certificates. So that's the initial stage, and what we do and what we have in our solution here is actually we automatically pull that all into a central system, And this is all powered by Relativity. So we built it in Relativity, which is a leading document review platform. And we've got our own application within there to really to help manage these claims and to manage these large number of claimants and their documents, and also the legal workflow and review process as you have to go through. Stephen just mentioned the sort of the three-step process. That's very much part of what we have built out within the software to make sure that happens very efficiently and is audited as well. So you've got the full audit history of what is going on there. Just a quick screenshot here. This is a typical, an example of it. Every case is certainly different, and so it have its own requirements. But these are the sort of things we would do. At the top there, we have a drop down, and in that drop down, you have many different workflows. This one is just focusing on the legal review workflow. On the top box there, we have the claimant details, which they've entered in from the microsite, which has automatically been then loaded into this system. We can incorporate signatures, etc. in there, so when we go through another phase of document production, we can also use that information to incorporate into that. And then you can see the legal review workflow, which will depend on what stage you are in onboarding or going through the verification of that claimant. You would see different bits of information in there. As you can see in this example, we've got an estimated value of the claim, some documents which are relevant to it, and also the status of that particular claimant is in the whole process. And being a database and using this type of technology, obviously you can filter down on certain people and particular parts of the process and hone in on information very quickly and easily. And then at the bottom there, we have as like a CRM system, really, a way that a communication record, so you can see when you've contacted the claimant. So it's very useful when you've got a large legal team or a number of people working on it. You can see who's spoken to that claimant and when they spoke to and what they spoke to about. Again, all centrally in that same system, so you don't have to go between different systems. And then finally, here we can see any documents which would relate to the matter. These will include documents they've uploaded at the outset, but also would include any documents we then automatically generate within the system, such as some agreements to go ahead with the action. Any documents maybe which need to be put together for the funders to sign off on. That's all automated, and so that would also go into that section there, and you'll be able to view them within the solution. So just a brief overview really of what we offer here. So we have a customizable solution which is always adapted depending on the nature of the action. We automate as much as we can in the whole system, so it's all about creating efficiencies. So we remove the admin burden as much as we can. We design the workflows for the legal process, so it is very straightforward and easy to put through many people, many claimants or companies as it may be, through the process in preparation for the funder sign-off. We also, we've got that CRM system in there that I just explained earlier on. And then we could build documents. So from templates, which are put together, we can then take the information such as people's names, signatures, value, amounts of money, and we can put them all into a final document, or group them up into a number of agreements for the funders to go through and to prove and push them over to the next level. So all of this data is one central solution. All the data is stored securely, and it's stored within the UK. Another advantage of having a system like this is you can really sort of build out dashboards to understand where you are in the process and just to get a sort of a general overview. And so here's a couple of examples here of the type of things that you can keep an eye on, easily generate reports from. A very useful way of presenting information to maybe a judge or to a funder to explain what you've got, where you are, and the sort of the breakdown of the action. So that's the software solution that can assist with the process to make it very efficient. You know, if anybody is interested, we can certainly give you a more detailed demonstration of that solution, so you can better understand it. But that's what we're going to cover today. So I'm just going to hand back over now to Claire to run through a few conclusions here.
Thank you, Martin. So I see it falls on my shoulders to draw some conclusions from this, the barrage of words and information we've just delivered. In short, I think the conclusion is taking into account the class action landscape as it currently is in the UK. There needs to be a team of professionals taking a very consultative approach to pursuing these cases and making a success of these cases. It will take different professionals and different experts to focus on the different elements that come about during the course of a class action. And they are, as you can see, some of them, the milestones, the more high-level ones outlined in the slide. I just want to home in on one there, really, which is the use of data. I mean, I think it's a given that the data needs to be used for disclosure, and you need to have an idea of the disclosure plan and the strategy of how that data is going to be used in the context of the disclosure. But what I think is vitally important is to also consider how that data is going to be used to craft the legal arguments and absolutely support the strategy, the legal strategy and the processing strategy of the group action itself. And by doing that and using and harnessing technology to underpin that thinking, it can only provide a very defensible presentation of the case, as well as a fair and consistent application of the principles across the whole claimant group. And as Martin already alluded to, by using technology to its absolute advantage, because it can be of so much importance in cases of this nature, you're necessarily creating an audit trail, so you are already very well armed to deal with any challenges by the other side. And I think overarching all of this is that if you've got a good consultative team, you've got the good legal professionals, good funding, good back office and technical support, these actions can work, and they can work successfully. Just to conclude, although I've already delivered my conclusion, I'm now talking towards the solution. But so what is the solution to all of this? I think that we have highlighted a lot of pains and pitfalls for all of you out there who are considering bringing these actions. Well, we would say, here we are, we're the solution. And our offering, combined with a good legal team and good legal expertise and a proven track record, can only help to begin to craft a successful framework for bringing these cases within the UK.
Thank you very much, Claire. That really concludes what we were going to go through today. I'll open the floor to any questions if anybody has anything. I think it was a lot of insight and opinion in what we've been delivering today, and I think it's been very useful. But if there is anybody out there with any questions, please do put them in now. There's none coming in as we speak, so I'll just leave it a moment or so. See whether there's any activity. We don't appear to be having any, so I would just like to thank everybody for joining today. I hope you found it useful, and if you'd like any further information, please do get in contact. Many thanks to both of our presenters today as well.